Well, Keith, we've been busy today working on a declaratory relief complaint that we need to file. And
Yeah.
then there's an underlying creditor's claim petition that we're filing. And we're just busy, and this case keeps interrupting us.
Yes, it does. I know. Another day, another filing, this time by Ryan Reynolds himself.
Never heard of him.
Yeah, well, you may be the only one in this universe who hasn't heard of him, but he has filed and he wants out of the case. And wow, the gloves are coming off.
The gloves came off in this one. I heard you laughing as you were reading it, and I'm sure we're going to get into a couple of things that you read. Before we do that, producer Eric is with us. Eric, welcome.
Howdy.
Glad you're here.
Thanks.
Could you do me a favor? I'm going to put up on the screen the 12B6 motion that was filed, and then I'm going to do a quick call out here. So this is a 12B6. We're all getting used to this. I mean, I think I saw somebody in the jury pool earlier say 12B6 motion to stay discovery, same day, different thing.
Right on.
So everyone's like figuring this out.
Good job.
But producer Eric, could you just first of all do a quick Google search and define what a 12B6 motion is? I'm going to put that up on the screen. I just want everyone to be on the same page. And what does it say is a 12B6 motion?
Oh boy. 12B6 motion to dismiss in the context of federal civil procedure challenges the legal sufficiency of a complaint, arguing that it fails to state a claim upon which relief can be granted.
Okay, so Ryan Reynolds is saying that Justin Baldoni has not made any claim where relief can be granted, and he wants the court to summarily throw Justin Baldoni's lawsuit out against him. If you can go back to the 12B6 motion that was filed today by Ryan Reynolds, I do want to point out that the attorney that signed this case, let's get to the very last page. The attorney that signed this page is Michael J. Gottlieb. Producer Eric, are we able to pull out who Ryan Gottlieb is for everybody, just so we can get some credit where credit is due?
Michael J. Gottlieb here.
Yeah, just read his profile. Let's learn a little bit about
Well,
him.
I looked. He went to Harvard Law, or did undergrad at Northwestern. Seems like a cool guy. Works at Wilkie firm.
Okay. It looks like he graduated law school the same year I did. So I wonder if he must be a few years younger than me, because I was in the military for 4 years. So maybe we're the same age. I can't really see him. How old does he look?
You tell me.
Okay. All right. Fair enough. All right. So there's Michael Gottlieb, and he's the one that drafted this. And really, Keith, I think the gloves did come off in this filing. Why don't you, without further ado, why don't you take us through some of the things that you saw with this?
Yeah. And I think it's important to point out, as the definition of 12B6 said, this is a very technical motion. And so really what the court is required to do is only look at what's said within the context of the Baldoni's second amended complaint and determine whether or not it states a cause of action. The court's not supposed to look at any other evidence. And so what Ryan Reynolds is doing here is he's saying that there has not been sufficient allegations made for defamation. That's the primary thing here. There's some other ones too on intentional interference, but it's mainly the defamation claims that he says has not been properly pleaded against him. And if we go to page 4, there's 2 bullet points. And so they're saying that, look, there's only 2 allegations in the first amendment. I said second amendment complaint. I mean first amendment complaint that Baldoni filed. He hasn't filed a second amended yet. There's only 2 statements in the first amendment complaint of Baldoni that even generously match the description that could be defamatory statements. And they point to 2 different ones. And one of them is the publicist, Leslie Sloan, this is the allegation from the first amendment complaint, went so far as to propagate malicious stories portraying Baldoni as a sexual predator, a term Lively's husband, Ryan Reynolds, also used to describe Baldoni when he called Baldoni's own agent. So that's the first statement, and they call that the agent statement that's in the first amendment complaint. And then the second one is Baldoni later received word that during the premiere of his movie, Deadpool Wolverine, Reynolds approached Baldoni's agent, namely an executive at WME, and expressed his deep disdain for Baldoni, suggesting the agency was working with a, quote, sexual predator. So those are the 2 statements that come out of the first amended complaint.
Was the executive Ari Emanuel, or do we know?
I think it was. I mean, they didn't say that in the complaint, but I think that's pretty clear who he's talking to.
Okay.
And so if you look at the next paragraph down after those 2 bullet points, what they're arguing is that apart from these two statements, the totality of the First Amendment complaint's allegations against Mr. Reynolds are that he demanded the Wayfair parties publicly apologize for so-called mistakes. So these are statements by Mr. Reynolds allegedly in the First Amendment complaint.
And the First Amendment complaint is filed by
Baldoni.
Baldoni. All right.
Number two, that was present during a meeting at the apartment. Mr. Reynolds was present at a meeting at the apartment he shares with Miss Lively, which he praised Miss Lively's version of the scene in Mr. Baldoni's presence. So in other words, what they're saying is that these statements here are not enough to meet defamation. Number three, allegedly contributed some writing of his own to the script. That would not be something that would be, I suppose, defamatory. Admonished Mr. Baldoni for asking about Miss Lively's weight and demanded that a scene be removed from the film. Number five, attended a meeting with Miss Lively to address her allegations of sexual harassment on set and demanded that Mr. Baldoni apologize for his conduct. Number six, unfollowed Mr. Baldoni on social media, and then included the Nice Pool character in Deadpool and Wolverine.
They're saying these are at best what you have in the First Amendment complaint.
Yeah, these are the best statements that you have in the First Amendment complaint. Now, I think that those statements in the First Amendment complaint are put there for context and background. That's why they're in the complaint. I don't think that every statement you make in a complaint doesn't have to show defamation. You're just giving the background of the case, and then you get to your legal arguments of defamation later on. So let's go down to page 6, and I'll show you under 2A. So,
Hey, real quick, how about this question? Is filing a motion to dismiss a fairly typical move by defenders in a lawsuit?
It is. Yeah. I mean, it happens all the time, especially large defendants, especially people who have deep pockets to be able to fight these cases. Procedurally, it's just something that you do. And even if you don't think you're going to win, you do it in order to make the other side have to work and put in the effort and spend the money. So right here, you can see on A, so the First Amendment complaint fails to state a claim for defamation against Ryan Reynolds. So that's what essentially they're arguing, is that if you were to look at all the allegations in the First Amendment complaint, it's not enough to state a claim for defamation. So let's go to the next page, page 7, and let's look at subparagraph 1 there. So they're saying that the Wayfair complaint does not sufficiently identify any defamatory statements published by Mr. Reynolds. So we'll get to that in a minute, but this is their argument. And then about halfway down, it says a long line of cases in the district holds that a defamation claim is only sufficient if it adequately identifies the purported communication and an indication of who made the communication, when it was made, and to whom it was communicated. Okay, well, that makes sense. I mean, if you're going to have defamation, you have to say who you communicated to. So let's go to the next page on page 8, and just the top kind of 4 lines of page 8. And we'll kind of see where this argument's going. So it says the first amended complaint fails to sufficiently plead the substance of the predator statements. Now, the predator statements is what they defined, those 2 bullet points up top. And it's where Ryan Reynolds allegedly told somebody at WME that Baldoni was a sexual predator. So they're saying that they failed to sufficiently plead the substance of the predator statements, which are the only ones relevant to the defamation claim. So in other words, they haven't said when it was said specifically, and it does not plead what Mr. Reynolds said, when he said it, or any of the context surrounding the conversation. So this is a very technical argument. In other words, what they're getting at is they haven't pleaded enough facts to say exactly when these statements occurred. Now, that's arguable because I think that we saw up above that the First Amendment complaint did say that at the premiere of Deadpool and Wolverine, that's when Ryan Reynolds allegedly made this statement. So it seems like that would be specific enough in my mind, but they're arguing that it's not specific enough. So now let's get to the really good part. And this is where the gloves are really coming off. Let's go down to page 9. And it's sub number 2, and highlight like the first 4 lines, or the whole paragraph even, that's fine. So this is a really good one. So the predator statements are not defamatory because they are constitutionally protected opinion. I'm sorry, what? So in other words, if you call somebody a sexual predator, then that is constitutionally protected opinion. That it seems a little bit of a stretch for me, because of the use of the term sexual predator seems a pretty drastic statement. Don't you think, Stuart? Versus just saying, you're a crook, or I hate you, or you're no good.
I mean, that's the whole point of defamation, is that you can sue people when they harm your reputation. And there's certain categories that are going to be more harmful to your reputation than others. If I went around and told everybody that you had a venereal disease, which he does not, but if I ran around and told everybody that, and then people believed that about you, it would impact your reputation. Is that freedom of speech of the person who's running around saying Keith Davidson has venereal disease? I mean, it's almost like music coming out of my mouth when I say that. It's such a wonderful thing.
Not to me, it's not.
Oh, I'm sorry. Did that offend you? So I think that the issue there is, look, there's free speech in this world, and then there's things that aren't free speech, and we don't give. It's free to say it, I suppose, but then somebody can hold you accountable for what you say. And if you call somebody a sexual predator, that can ruin their reputation. It can damage them. It can harm them. It can keep them from future movie roles or just working as a regular person. If I went and told every law firm in California that you were a sexual predator or this or that, and they believed it or didn't want to get close to the drama, and you were damaged because you couldn't find a job as a lawyer after that, even though you're a perfectly fine lawyer, you would have a cause of action against me, and you could sue me for that. And if you said, oh, that was just my freedom of speech, it was just an opinion, and I'm just making an opinion, I'm just joshing, I'm just having some fun over here, I don't think that's appropriate.
Okay, so let's look at what they're quoting to on page 10.
And that's exactly what someone said. He said he used that opinion to affect his being Baldoni's career.
Yeah, exactly. And I think that's when you're crossing the line.
Thank you, Misha. That was a nice comment.
Let's look at the first 3 lines on page 10. And they actually they put this in bold. So they're saying, and this comes from a case that they're citing to. So use of colorful language such as predator, victimize, or face of evil are not actionable in and of themselves. Okay, but I think, again, you have to put it in context. And so if I said Stuart's the face of evil, and
I don't like it when it's my turn.
No, you never seem to like it when we turn the tables. But I think in what context am I saying that? Am I saying it with a group of friends, or am I saying it at an lawyer event where you're on stage presenting and I say he's the face of evil and it actually hurts your reputation? I think you have to put this stuff into context. And so when somebody is going up, especially in Hollywood, and you're going to a group of people and a powerful agent, and you're saying you have a client who's a sexual predator, that's the allegation of what was said. I think that goes a little beyond opinion versus if you went up and said, I think one of your clients is the face of evil. I think people can see that, well, that's your opinion. I mean, how do you prove that somebody is or isn't the face of evil?
Yeah, I don't know about that. The one thing I know is if you are calling somebody a sexual predator to somebody in Hollywood, especially with all of the Me Too issues that have gone over the last few years, that is a career-ending description of somebody, and it can harm somebody. And here, Justin Baldoni is saying in his complaint that you should not call me a sexual predator. And I was playing kumbaya and holding hands with everybody, hoping that Ryan Reynolds and Blake Lively would come to their senses and say, I think we may have overstated some stuff. Maybe there was some misunderstandings on our part. It led us to make stuff up in our minds that maybe wasn't actually there. And now we need to take responsibility for this. There's going to be a payment of money and there's going to be an apology. But what I'm seeing here from these lawyers is, no, they're doubling down. This 12B6 and this is the most ferocious 12B6 that I've seen thus far in the case when they're making these statements. Let's go on to some of the other things that you found that were funny.
It gets better. Yeah, let's go to page 11. I just want you to go to page 11 and highlight little double I there.
Real quick, I want to get to this one from Jennifer O'Sullivan. Thank you for the support. She says there was no allegation of SH before December 21st. Sloan has stated that she was unaware of SH allegations at the time. Just H, I guess that just means normal.
Just harassment.
Yeah. Ryan Reynolds' predator statements preceded the SH allegations by months.
Yeah.
Is that relevant?
Yeah, I think it could be. I mean, again, I think that, Ryan Reynolds had a certain opinion of Baldoni, and he stated his opinion in no uncertain terms. But then the problem is that it went beyond opinion, and then he's saying that he he affirmatively said, allegedly, if he said it, is that Baldoni is a sexual predator. I think that's an assertion of fact.
I don't want to get into too much speculation here, but Ryan Reynolds, he's I have to admit, I actually watched It Ends With Us the other night for the first time.
Oh,
I've never seen the movie before. Lots of kissing. I mean, there's a lot of kissing going on in that movie. And is this something that bothered Ryan Reynolds? I think Zach Peter has talked about the issue that Ryan and Blake met on a set, and maybe they were dating some people at the time or something along those lines. I don't know all the facts, but I just know that there was some jealousy involved there. And then here this person is, I was watching Justin Baldoni on It Ends With Us the other day. I mean, good looking. Have you seen his abs?
I have not. No.
Wow. I mean, and he's handsome, good looking. I mean, I would be intimidated if he was kissing my wife. So, I think you'd have to be concerned about that. But is some of this just that was happening? I think there was also the issues with Blake telling Ryan that Baldoni had talked about her weight. So he's already angry. He's not feeling good. And you want to come to defense of your wife. So how much of this was just misunderstanding that was going on? But obviously, when you go around and tell publicly people that this person is a sexual predator, well, you have to live with what you said.
Yeah, and that's a pretty strong statement. And look at little double I here. If the predator statements are not opinion, they are substantially true. So then it's like, whoa, okay, now we're doubling down on the double down.
So let's talk about that. So, if you remember, if you hear people say, it's in my opinion, Keith Davidson, is a loser. Chances are you get away with that because it's just an opinion, right?
Yeah.
Okay. But if I say something about you that's detrimental to, maybe I do call you a sexual predator, and maybe you are a sexual predator. Do I have a defense if I call you a sexual predator and you in fact are a sexual predator?
Yeah, the truth is always a defense to defamation.
So what they're saying here is, first of all, this was just an opinion statement by Ryan Reynolds. But hey, even if it wasn't an opinion and it was a fact, it's true.
This guy's a sexual predator.
When I heard you tell me that they wrote this here, I didn't believe it. I had to look for myself.
Yeah, I was pretty perplexed by it myself when I saw it. I'm like, wow, okay, they're dropping a bomb right here. So let's go down to page. So on page 12. And it's the first full paragraph that starts with the FAC includes numerous references.
We got another comment that says, you lose them the way you got them.
Yes.
Yeah, Ryan Reynolds was married to Scarlett Johansson at the time.
Yeah.
So this is where they're saying that the First Amendment complaint includes numerous references to conduct that a reasonable observer could well consider predatory. Oh, okay. So now he's just saying, hey, I have a right to say this guy is a predator as far as I'm concerned. So
and he's going to use his own First Amendment complaint against him?
Yeah.
Okay.
And so in particular, well, he's actually going outside First Amendment complaint a little bit here. So in particular, the First Amendment complaint relies on Mr. Baldoni's books, Boys Will Be Human and Man Enough, and his podcast, Man Enough, even going so far as to declare that anyone who knows Baldoni would have knowledge of the contents of Mr. Baldoni's books. Okay, well, I don't think his books say that he's a sexual predator, but I haven't read his book, so maybe they do. Let's go down to the next paragraph on the same page. So here it says, those materials with which anyone who knows about Mr. Baldoni would be familiar include numerous admissions to behavior that could reasonably be described as predatory. In particular, saying that, and this is actually taken, I think, from YouTube, saying that I'm sure I have crossed boundaries and lines in my teens and 20s, not even thinking about it, simply because of the porn I was consuming. Okay, well, I don't really think that makes him a sexual predator, but that's the allegation. Now, interesting thing about this quotation is not from the First Amendment complaint, I don't think. I don't see it in there, is it?
I don't think it is in the First Amendment complaint.
And they were talking about something that was said on YouTube. So this is something you're not allowed to do in a 12b6 motion, is you cannot go beyond the four corners of the First Amendment complaint.
And here in this case, where they have gone beyond the four corners of the complaint, who do they want to consume this news?
Oh, the public.
Yeah.
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 Yeah. Yeah. I mean, it's a good point. And it's something that we've alluded to actually said many times, is that a lot of these pleadings are being drafted, not just for the court, but for the public.
It almost forces Baldoni to actually address this comment again and publicize it again in his opposition to this 12b6. It's a really tough place for Baldoni to be, because he actually has to talk about this now, where they've doubled down and they basically said, hey, Ryan Reynolds called you a sexual predator, but you kind of called yourself that. And then you get caught in the, well, this can't even be considered. And then, of course, what does the public opinion say? Well, what, I can imagine somebody arguing on Ryan Reynolds' side, well, he's trying to hide this away now. See, he won't even let us talk about this, when that's not the standard. The standard is you have to look at the four corners of Justin Baldoni's First Amendment complaint, and that's the only thing you can use to come after him. Now, if Mr. Baldoni included his YouTube clip in his First Amendment complaint, it's fair game. You can talk about it, you can bring it up, you can argue it, but I don't think it's in there.
No, it's not in there. And then let's go to page 13. About halfway down, there's some text in bold font, and it says, and because we never...
In the meantime, I'll put this up from Anna Pham. I don't want to get in trouble here, but she said she's saying Candace Owens thinks Ryan is gay, by the way. Maybe he wants Justin instead. Again, I don't know if I think that's funny or not. Maybe it is. But by the way, Candace Owens, she's pregnant right now. I was telling Stuart this, and I reached out to her, but one of her reps got back to me. Say what you want about her, but she probably gets a lot of eyeballs. So maybe after her pregnancy, she would come on the show.
Oh, that'd be awesome.
That'd be great.
That'd be a privilege.
So look at right here, the bold text. And because this is again quoting Baldoni, and because no one ever sits us down and teaches us about consent, we learn it through porn. And so again, they're using his words against him. And then at the bottom, I wanted as a man to claim her publicly, as on some level I knew it would make me feel more like a man. Both of these citations are from his YouTube videos. Again, they're going beyond the First Amendment complaint. It's not appropriate. The judge will most likely not consider this as part of the argument because it's just not allowed to do that. But I think you're right. I think they're doing it for the public. But even so, does this still make him a sexual predator? Now let's go to the top of the next page, page 14, the first like 4 lines on page 14. And it says, while it is unclear what predator means to an average listener, well, I kind of feel like I know what predator means.
Are you an average listener?
I would think so.
I'm an average listener.
I like to think I'm above average in most things, but I'm probably average.
Are you what is it, a mommy sleuth?
Yeah.
Sorry. Are you an average listening mommy sleuth?
Or, well, I mean, I feel like I'm average, at least at a minimum. I don't think I'm below average. So while it's unclear what predator means to an average listener, okay, it's quite clear that there is no discernible distinction between the gist of Mr. Reynolds' purported statement and the very behavior to which Mr. Baldoni has repeatedly confessed. Okay, so think about this argument for a minute. So what they're saying is Ryan Reynolds calling Baldoni a sexual predator is no different from what Baldoni has called himself. Do you buy it?
I don't. And I also think that's interesting how they couch Mr. Reynolds' statements as purported statements now. So they're saying, well, hey, these are his purported statements. So, we don't know if he said them, if he didn't say them, but hey, we've got Mr. Baldoni saying the same thing. I actually did watch Mr. Baldoni's TED Talk. It's probably been several months back.
Yeah.
And I was very impressed with it. It seems like he got in touch with himself as a man, saying that he was not giving respect to women the way that he should. And I don't think he was saying it in the context of being a sexual predator. I think he was saying it as a decent human being, that he had taken stock of himself and thought, how can I be better? And I think part of this speech, if it's the same speech that I saw, was he was not listening to his wife. His wife would be talking to him and he would discount what she had to say. And he had to check himself and he had to say, wait a minute, I need to listen to what my wife is saying. She should have the same ability to share her opinions as I do. And I got the feeling he was just talking to men in general about, hey, take a time out, guys. Think about how you're dealing with other women and give them the same voice that you have for yourself. Because, we men are louder. What woman hasn't been in a board meeting where she's thrown up her hand and gave an idea and nobody says anything? And then a man 5 minutes later will say the same idea and everybody's excited about it. I mean, I've heard lots of women say that to me, that they just feel unheard. I think Justin Baldoni was talking about how do we men take stock of ourselves.
Yeah.
And I think he was talking about maybe, in his early days, when he was dating people. But I don't get from that he's a sexual predator. And again, the tone of this 12b6 is not helpful to the case. I don't know if Ryan Reynolds, again, who's running the strategy of how this defense is to be run?
Well, it's definitely coming from somebody who wants to put something out in the public eye that is very aggressive. There's no doubt about that. And, we can ask our jury pool, we think you're above average listeners, but do you understand what predator means? Because they're saying that the average listener, it's unclear what the term predator means. I don't think it's that unclear.
Yeah, anybody wanted to give us a short definition of predator, throw it up there. Again, I'm an average listener. I'm not ashamed of that. I think I know what a predator means.
And then when you add sexual predator,
I know what that means too. And when I think of sexual predator, there's people that come to mind. I'm not going to say any names. I can say Ted Bundy, but I'm not going to say any names, in the civil realm because I don't want to impugn anybody. But there are people we think about as sexual predators. I personally don't think of Justin Baldoni as a sexual predator.
No, I don't either.
I thought this was a interesting comment to at least maybe start a discussion. And Humanity in Crisis says Justin's problem is he's just not fighting. He wants to be a Buddha in a knife fight. That's kind of funny. But I think people might think that, but is there anything really he can do at this point?
Well, I think he came out swinging. Approach? I think Friedman did a wonderful job of fighting for Justin Baldoni. Now, I think that so far everything that I've seen on the Baldoni side has been arguments and fights that are at least reasonable and maybe civil. Whereas I feel like now this is crossing a line where things are getting really aggressive. Let's go to the bottom of page 14, the last paragraph. Do you still have that up?
Yep.
Because this is the interesting part. So here's how this argument comes together. So what they're arguing is it would be perverse to permit Mr. Baldoni to build an entire brand, complete with a podcast, TED Talk, and books, off of his confessions of repeatedly mistreating women, only to turn around and sue Mr. Reynolds for $400 million for simply pointing out in private what Mr. Baldoni has bragged about in public. Now, this really goes to your point, Stuart. Now, this is for public consumption right here.
Yeah, and again, it's just not needed. And I'm frustrated by this case because I want to say shame on you, to the lawyers that write this. I want to say shame on Ryan Reynolds if he approved this. This is not the direction you guys need to go in the case. You're doubling down. You're making things worse. The sexual predator issue was a difficult one for Mr. Baldoni to swallow. Brian Friedman has made it clear that they want to be vindicated and that they're going to trial. All lawyers say they're going to go to trial. But at the 12B6 motion here, you're making it harder to resolve this case because now what you've done is you've dropped a nuclear bomb when you didn't need to. And the statements that are being made here are harsh. I think they're overly stated. They're overly argued. This is not helpful. And I'm not sure, it reminds me of the SNL moment. What did Ryan Reynolds think he would get out of that?
Yeah.
I don't know if Blake Lively knew about that or not, but what were they hoping to get? And my same question would be to these lawyers, what are you hoping to get out of this 12B6?
Right.
Because what you've done is you've just insulted the man again in the strongest language possible. And now he's in a position where you've painted him into a corner where he is going to ask a jury to determine this case because he feels like you're wrongfully attacking him here.
Yeah. Because the argument so far is I didn't say sexual predator, but if I did, it was opinion. But if it's not opinion, it was true.
Yeah, and if it's true, then it's a fact, and it's I'm not liable for defaming somebody if I say something about them, even though it's mean and it's true.
And it's because Baldoni has called himself a sexual predator. I don't feel like Baldoni's done that.
And can I say one other thing?
Yeah.
And again, we've talked about this, that look, guys, jury trials, and you guys are the jury pool right now, but juries use their common sense. Juries are smart. They are the smartest group of people in the room, and collectively together, they look at these cases and they use their common sense. And I think that if you're asking 12 people to believe Mr. Baldoni's TED Talk, which will certainly now be played in court in front of them so that they can take a look at this, are they going to come away from that thinking that he is admitting publicly to being a sexual predator?
No. I watched it because I didn't watch it right away, but I did go and watch it. And I remember when I did watch it, I was a little surprised because the way that it was being described by the Lively and Ryan Reynolds camp, I thought it was going to be terrible. But I agree with you. It actually was quite good, and he did a good job of it. And you may not agree with him and everything he's saying, but his heart was in the right place, and he was being very open and honest about his feelings. And I don't think you can fault anybody for that. I also want to point out that in that statement, it said that Mr. Reynolds shared something in private. It's important to know that for defamation, you can be sued for defamation if you say something to just one other person. You have to, quote unquote, publish, but that doesn't mean put it in the newspaper. That means say it to at least one other person. And he just happened to say it to a very powerful agent that it looks like ultimately dropped Baldoni because of it. So, to say that Mr. Reynolds said this in private, I don't think that helps your argument in terms of trying to get out of the case.
Agreed.
Yeah, and I just wanted to bring this one up. This is one of our jury pool members. They say, average listener here, I see a huge difference between Baldoni talking about himself in the context of taking responsibility of one's actions and Ryan calling him a predator in context of Blake's SH.
Yeah, so that's what I took from the TED Talk was he was asking men to be better, to check ourselves, to think about how women feel about some of these things, to give women a voice, to be kind and considerate. And I know he's from the Baha'i faith, and the Baha'i faith, there's some very good people in the Baha'i faith. I think Rainn Wilson from The Office, I think he's Baha'i. There's this idea that they look at every religion, and I'm not an expert in this at all. Somebody in the jury pool could correct me where I'm wrong, but the Baha'i faith looks at all religions as kind of stepping stones that you bring all the religions together and you take the best out of all of them to create this ultimate idea of love and care and being kind and generous to one another. And, I think that this is who Baldoni is as a person. And I think he's sitting there he's not a professional speaker by any means.
Yeah.
But I thought what he was trying to, I didn't walk away from that going, oh, this guy's a sexual predator.
No.
I walked away from that going, what do I need to do to check myself, to make myself better in how I treat women?
Yeah. And so, some people don't like that touchy-feely, emotional, and that's fine if that's not your thing. But yeah, I didn't walk away from it thinking that it's a sexual predator issue. Let's go to the next claim, which is tortious interference or intentional interference with a contract. This is on page 20, and starting with section 2. And I just want to go over. So now, those were the defamation arguments as to why they think it should be dismissed. And intentional interference with a contract, it's kind of an interesting concept. And you'll see in the first paragraph these are the elements for that claim. So you have to have the existence of a valid contract between the plaintiff and a third party.
Such as their who? WME? What are they?
Yeah, WME, an agency, and Baldoni. So that would be a contract between those two parties. And defendant has to know of the contract, defendant's intentional procurement of the third party's breach of the contract without justification. So in other words, somebody has to kind of force one of the parties to breach that contract without some justified way to get out of the contract. Number 4, actual breach of the contract. And number 5, damages resulting from that breach. So they're saying that to survive a motion to dismiss, the plaintiff must specifically plead the existence of a valid contract and must identify what provisions of the contract were breached and a result of the act as at issue. So you don't see this claim a whole lot, but it is an interesting claim. And it does seem to go to this issue of, did Ryan Reynolds get WME to fire Baldoni, and would that be an intentional interference with that contract? Let's go down to the next page, 21, and it's the first full paragraph that starts with the FAC fails each of these requirements. So they're saying that the sole contract alleged in the complaint is a contract between the Wayfarer parties and William Morris Endeavor. But the FAC does not allege any details about the contract, including which parties it allegedly bound. It says surely not all 7 of the Wayfarer parties, what the contract terms were or what provisions were allegedly breached. So I think that it does. I think the First Amendment complaint does make clear that there was a contract that was breached. If the judge were to look at this and say, well, I think that you need to state what provisions were allegedly breached, that could easily be cleaned up in a second amended complaint. But I think there was a contract here. And I know that people had been asking, is there anything that Baldoni could do in response to WME having fired him because of Ryan Reynolds? This is what Baldoni is doing. He's bringing this claim.
Right.
Let's see. So let's look at page 22, and it's the paragraph at the bottom of the page. So the FAC. So we're still talking about that. They're saying, Ryan Reynolds is saying that Baldoni failed to state a claim for intentional interference. And this says the FAC does not even attempt to allege that Mr. Reynolds acted solely out of malice, as is required to survive a motion to dismiss. But the FAC itself asserts that Ms. Lively and Mr. Reynolds were motivated, at least in part, by a desire to seize control over a film production. So, I mean, I think that you don't necessarily have to use any magical words in a complaint. I don't think you have to say malice. You just have to allege facts that go to that effect. And I think that there are facts, especially seizing control of a film. I think that that would be facts that could show actual malice for wanting to intentionally interfere with a contract. So that's really the intentional interference claim. And then I just want to skip down real quick because there's something really interesting that's in the last section. Well, two things. So let's go to page 27. So on number 3 there, so the court should award Mr. Reynolds attorney's fees pursuant to New York's anti-SLAPP law. So not only does Ryan Reynolds want this case dismissed against him, but he wants attorney's fees for his efforts. And Stuart, what's the deal with these attorney's fees on anti-SLAPP laws and how that works?
Well, I'm not familiar with New York's anti-SLAPP law, but I am with California, and it's very expensive. And, essentially what you're doing is with an anti-SLAPP is you're resolving the case really before you get into all the evidence. And so you are summarily here at a 12B6 motion. Here in California, it would just be an anti-SLAPP motion filing. If you win it, you're entitled to attorney's fees. If you lose it, you don't have to pay the other side's attorney's fees. I'm not sure how New York works. I'm assuming it's similar.
Probably.
Yeah. So, and anti-SLAPP has been used in such abusive ways, in my opinion. Opinion, not fact. Making that clear. Because it was really set up to help little people. When I say little people that don't have a lot of money, and they would come to the court system and file against a big developer. That's really where the genesis of the cases were. And the big developer would just overwhelm them with 12B6 filings and motion, just every filing that could be made. And before you know it, these people are bankrupted and they never get their claim heard in front of a jury because they just don't have the money to get there. And so anti-SLAPP was created to help that. But now everybody's using anti-SLAPP, and wealthy people are using it against wealthy people and vice versa. It was a good idea at its time. I'm just not sure that it works real well here. But here under New York, apparently, if Mr. Reynolds is successful, then he would have attorney's fees awarded to him after the 12B6 and all the claims he's made in here. Yeah,
well, that'll be interesting to see what happens with that. Let's go down to the last page, page 29, section 4.
Real quick, Bridget says, "Hey, lawyers, I work in film and I've never seen anyone take over a film like this. I'm still stunned by it. It's so obvious."
Yeah.
Interesting point.
Yeah. The whole takeover of the film. I mean, that's why they put it in the complaint. I mean, it certainly would be a fact that I think a jury could find actual malice.
One thing that I've thought about is that Brian Friedman did a really good job of putting together an Exhibit A that he filed with the federal court. And in that, he apparently put every single text, because the text had been taken out of context that had been given to the New York Times. And so Brian Friedman did a masterful job. And he even tries to use a neutral tone as he's going through it. I don't know that he hits on a neutral tone all the way through. He does represent Baldoni after all. I'm sure he wants to do well for him. But if you read that Exhibit A, it's riveting. It'll take you a couple hours to get through it, and it gives you beginning to end. So if I was Ryan Reynolds, I'd be really concerned about that Exhibit A. What do you think, Keith?
Yeah, well, I think he is, because look at the section 4.
Oh, what happened?
He wants the court to strike Exhibit A to Baldoni's first amended complaint. I mean, this is really amazing. And, he's saying that as this court has recognized, permitting a party to satisfy its pleading requirements by attaching documents other than instruments to the complaint would do considerable damage to Rules 8 notice requirements. So in other words, he's saying they put too much in here. And so the other motions to dismiss against Baldoni,
there's not enough.
There's not enough. And in fact, in this one too, right? When it comes to other claims, there's not enough. There's not enough for defamation. There's not enough for intentional interference. But when it comes to this Exhibit A, there's too much.
What is it? Goldilocks?
Yeah.
It's too hot. It's too cold.
Right.
This one's just right.
Yeah.
Yeah.
So, I mean, it's interesting to me that he wants the court to strike Exhibit A. Well, it makes sense. I could see why. Now, that doesn't mean that all that evidence goes away, by the way.
No.
I mean, it's still there. It's still evidence. It'll still be used in depositions. It'll still be used in discovery. It'll still be used at time of trial. But it's interesting that they want that stricken from the record. And the thing that I was impressed with that Exhibit A when you read through it is it does have a little summary up top before the text,
Yes.
each text session.
Yes.
But the summary is not, it does not overstate what the texts say.
It doesn't seem to.
It doesn't seem to. It seems like
Yeah.
the summary is just very, very close to what the texts actually say. That's not always the case when you see summaries like that. Sometimes people try to go too far and then you hurt yourself because it's not true based on the text.
So Keith, I still don't understand this. I mean, again, I don't want to denigrate any of the lawyers in this case. And this actually, obviously a very bright lawyer put this together. I personally wouldn't have put it together this way because I think it's too harsh. I think it's too harsh to Justin Baldoni. What's the goal here? Is the goal just PR? Is the goal to win? A little bit of both? I mean, what's going on in your mind?
I think a little bit of both. I mean, number one is I want to strike back. I mean, you can imagine Ryan Reynolds being like, we need to punch back. Everybody's against us. We need to throw a right hook. So that's one thing. So it's probably anger, want to strike back. And then number two, it's not uncommon for defendants to file a motion to dismiss. But to do it in this manner, I agree with you. It's gone very aggressive. And again, the arguments are, I never said sexual predator, but if I did, it was my opinion. But if it's not opinion, it's absolutely true based on what Baldoni said about himself. I mean, those are really aggressive arguments.
Yeah.
Is there a way to have structured this motion without that?
Yeah, there absolutely was. I think a lighter hand would be the way to go. But I'm sorry, Carol Thomas has something. Go ahead.
Yeah, it's okay. I thought this was a great segue, and I kind of was thinking the same thing. Carol Thomas says, "I don't see this case settled with an apology. This is a clear example that this is going to court." I mean, what is it looking like, guys? The gloves are off.
So, Carol, thank you for your comment. I think, unfortunately, you're correct. I'm not upset that you're correct, but I just feel like this case, like all cases, I'm constantly reaching out to lawyers now that I've become an older lawyer, and I'm constantly saying, today I reached out to a lawyer and I said, hey, why don't we resolve this case for our clients? No, we're going to litigate it. We're going to go all the way to litigation. I said, look, we're going to resolve this. I know we're going to resolve it. Why don't we just do that now? Why don't we save our clients? I mean, we've already exchanged information. Everybody knows what the case is about. I was hoping that this was where this case was going. And Blake Lively and Ryan Reynolds, I had pointed out that they're human beings too, that this is very painful for them to go through. And I believe it is. I don't think just because there was this filings made, it wasn't painful. It's not painful for them to go through. Litigation is painful for everybody. But the strategy, the tactic here, I just think it's a little heavy-handed. And you still could make your point if you need to, file it, make a good, strong point, see if you can win on 12b-6. But ultimately, are those conversations happening that I've been talking about? Is Team Blake Lively, are they reaching out to Team Baldoni and saying, hey, can we get two lawyers at least? Carve two lawyers out and have them start talking and seeing if there's ways to resolve this. And as the comment just says, I don't see it resolving for an apology. I don't see it resolving for an apology. But go ahead. Sorry.
No. I don't see it either. I was going to ask you this, though. If this motion to dismiss had not been so aggressive, so you go ahead, file your motion to dismiss, you make your arguments, you don't make it quite that aggressive, would it actually have been a better reflection and more powerful for Ryan Reynolds?
Absolutely.
And
absolutely.
Why?
Well, because now you don't have the venom. And, now you don't have Justin Baldoni going, if he was even considering possibly resolving this case with them, now he's saying, well, Matt, look what they're saying. They're still saying this about me. Or at least they're indicating that I'm a sexual predator. And even if it is a fact, there's truth to it. And by the way, you're the one who said you're a sexual predator. It's a bit disingenuous from my standpoint to say that Baldoni has come out publicly saying he's a sexual predator. No one ever comes out and says, I'm a sexual predator. I mean, that's not what sexual predators do.
But don't you think it would make Ryan Reynolds look better if he came out and wasn't so aggressive just in terms of the public persona, in the public perception of him?
It would be. I mean, if you come out and just fight with respect here and fight on the merits and say, hey, we shouldn't be in this case because it doesn't meet the elements that we've provided to you, Judge. And again, the lawyers will say, well, the only way we could show that was to say that, well, he said he was a sexual predator. Look, if he came out on YouTube and said, I am a sexual predator, well, then use it. But that's not what he said. And I don't think a jury is going to believe that's what he said.
And they're using things that go beyond the four corners of the First Amendment complaint.
And that leads me to believe, again, unless we've missed it in the First Amendment complaint, I don't think the YouTube talk is in the First Amendment complaint. These lawyers are smart. They know better in my mind than to put this into. Now, maybe there's some rule that I'm not aware of in the second district where you can look to extraneous evidence to resolve a 12b6, but I've never heard of that procedure before.
Yeah, I don't think so. And I think it's more for public consumption.
Here's another question. Are they using the motion to further smear JB, knowing we will talk about it? That the content will be publicized? I don't know if that's clear to you guys. But
Yeah, I think so. I think that was Stuart's point, is that a lot of this is being done for public consumption, and it's to try to change the PR war. But I think they went about it the wrong way. And I think anytime you come out and you say, well, he is a sexual predator, it just doesn't look good. And with these facts, here's the problem. They haven't presented us with any facts or evidence that shows that, but Justin Baldoni is in fact a sexual predator. The reason Ryan Reynolds seems to be thinking that he is, based on these arguments, is because of apparently what happened in the film and these TED Talks, and we've all seen them, and none of us are looking at it saying sexual predator. And once again, you're going too far. You're going beyond the reasonable implication of the facts and the evidence. And you're always going to get yourself in trouble when you do that, especially in court, in the court of public opinion. But when you're in front of a jury, you're going to get yourself in trouble. Like, what happens when you're in front of a jury and you misconstrue statements, evidence, or you overstate your position?
Yeah, they pick up on it so quickly. And this is something that lawyers need to understand. The minute you walk into a courtroom, that whole thing is about credibility and truth. That's what you have to build as a lawyer through the entire trial. That starts at voir dire. It goes into opening statement. It goes into direct, cross, closing. When you get to closing, the jury should look to you because they know that they can trust what you're saying, that it's based on the evidence, that everything that the jury heard in that trial, it's just like Mr. Davidson said it was going to be. Look at that. It's all flowing very nicely. And when you get to, these ticky-tacky arguments, now, they may not make these arguments in front of a jury. Maybe in front of a jury, it'll be, more of a velvet glove approach. But I'm just pained because I feel like before this was filed today, I feel like this case had an opportunity to resolve. And I think it would be good to resolve. I'm always for cases resolving. I know there's lots of people that want this case to go. But now, those people that want it to go, they're going to probably get their wish, because if you're Justin Baldoni, you cannot stand for this. You have to fight back. And the only way to fight back is to vindicate your name. There's risks. Justin Baldoni has risks going to trial. No case is perfect. Every case has problems, including Justin Baldoni's. I think there's probably, from what I've seen, more problems on Blake Lively's side, though.
Yeah, I think you're right.
Lori Lundquist wants to know, what will the judge think of the tone of this motion?
So, judges are used to seeing all sorts of different tones. I don't think that really affects them much. I think the thing that I would be affected by as a judge reading this is, number one, you're saying things that go outside the confines of the First Amendment complaint. I'm not going to look at that. That's not what the rules say for a motion to dismiss, number one. And number two, I have to liberally construe the pleadings in favor of the plaintiff. So if there's any way that I can look at this and say that the plaintiff has stated a cause of action, that's how I have to rule. Now, the judge is probably also thinking, I kind of hope Baldoni files a second amended complaint and maybe we clean some of this stuff up, because that way you'll still get motions to dismiss on a second amended complaint, but at least it'll be a little bit cleaner, a little bit tighter, and it might make the judge's decision making a little easier.
That's true, Keith. I agree with that. The one comment I'll add to that is that I think that Baldoni's team did a great job of responding to the New York Times 12b6, giving a masterclass in what you are required to put it into a pleading. And it's much like California. It's a notice pleading. Have you put the defendant on notice that this is what you're doing? And so if there is a second amended complaint here, it will clean some stuff up. This is, I think the public at large, our jury pool, is learning that in litigation, everyone thinks everybody gets their day in court. Everybody gets their day in front of a judge or a jury. To get to a bench trial or a jury trial, it's a marathon. It is difficult because there's these paper wars, and these are paper wars that are happening right now. And we're just at the beginning of the paper wars, and they're going to continue. And, do we make a March trial date? Federal courts are really sticklers to trial dates, but do we make a March trial date with a case that's this big, with this many motions that will be filed, with the millions of dollars that are being spent every single month where we're at right now? Discoveries being propounded. People are filing motions to stay discovery. This is really being fought hard. And today, I feel like it really forces Brian Friedman and his team to continue to fight this fight.
So we went up another level, and it's not a good progression
It's
for
not-
either side.
It's not, I still believe that any case can settle. It's just that everybody's watching this case. And when you're using arguments like this, somebody had a strategy somewhere. I'd like to talk to them about their strategy and ask, because maybe they met their strategy. Maybe it was to get people talking about this. Maybe it was to insult Baldoni. Maybe they truly believe that the judge will be convinced that Baldoni has claimed publicly multiple times that he's a sexual predator. I don't think that's what's going to happen.
No, I feel like it's a little bit of a tone-deaf strategy. I noticed on the scheduling dates that the court put out that on August 14th, the parties are supposed to be done with their fact discovery, even though the trial's not till March. And so I'm thinking that the reason the judge did that is knowing it was going to be continued. There's no way they're going to be done by August on fact discovery.
Yeah. And by the way, this is just fact discovery. Wait till we get to experts. I think, what is it, August or September, October?
Yeah.
Experts will be a nightmare. That's always a tough one. And then as they get closer to trial, I have said that I think there's a 90+% chance that this case settles. I'm going to have to reevaluate that after this filing.
Yeah, me too. I know.
It's unfortunate.
Yeah, it really is, because you didn't have to go in this direction. And I don't think it did Ryan Reynolds any favors, not in the court of public opinion or not in the actual federal court either. I think it's just very unfortunate that that's the case.
Here's a good one from Soy Nadja. Question for Stuart and Keith. Can the jury rule for Blake and Ryan to publicly apologize to Justin? And can the jury draft the apology or decide who?
That'd be awesome.
That'd be fun.
Good question.
Yeah, no, that is not one of the remedies available to the jury, unfortunately. So all they get to decide is damages and how much.
Let me say, though, if you bankrupt somebody with a jury verdict, that's kind of forcing them to apologize, isn't it?
If you want them to get out of the judgment, yeah, for sure.
And that's the other thing is, how much is Ryan Reynolds and Blake Lively worth? I think that there's people they've been guessing about that online. None of us know for certain. But if you ended up with, nobody can afford a $400 million judgment.
Oh, yeah.
Or even a $100 million judgment would be very brutal for most people to incur. So, does he have the ability do he and she have the ability to pay for it? I don't know.
Yeah. And like in California, judgments incur statutory interest to what, 10%?
10%.
10% on 400 million. It's like you hope they never pay it. Just collect the interest.
It's a good clip.
Yeah. It's a good clip, right?
We can wrap up with some other comments. JT says, "Are you guys in the same room with different cameras, or
we are.
You in different offices?"
We can see.
Trying to get there.
With pictures on the wall.
It's funny because Stuart's son came in the other day and he's like, "I can't believe how close you guys are sitting in real life, because on the camera it looks like we're far apart, but no, we could actually hold hands."
We are just humble country lawyers, and so we are going to get a new camera. And that camera will go and it'll actually show us together, and then we can.
Yeah, we're trying to do some new camera angles.
Yeah. Karen Vick says, "Thank you for your great insights, learning a wealth of info and loving your podcast."
Oh, wow. Thank you.
Karen, thank you so much. Our goal here is to educate on the legal system, no matter what the story is. Obviously, this is the story of the hour, but we also want to talk about the Trump administration, and federal district judges making orders that are apparently being ignored by the Trump administration, the constitutional basis for that, what the different branches of government are and how that works, how the checks and balances work. We're just excited to share what we've learned during our short period of being lawyers.
Yeah. Nick Knack wants to know, can we get Ask Two Lawyers jury pool merch? I've been racking my brain. What do you guys want? Please leave comments. There's always a normal
Well, we definitely
hats,
need mugs. I want a mug.
T-shirts, but
yeah.
Anything else people are interested in, let us know.
We could get a thigh master.
I'm going to leave that alone.
Molly said, "As soon as I saw the headline, I ran over to YouTube hoping you'd have a video about it."
Oh, nice.
Thank you, Molly.
Asking you shall receive.
Yeah, we're happy we were able to squeeze it in this afternoon. We weren't sure we were going to be able to, but we were going to try and do
to be honest, Keith was headed out the door, and I'm tired because we've been working on this stuff since early this morning, and not this stuff, our stuff. And I finally said, "No, we got to talk about this."
Yeah,
the jury pool would want us to talk about it.
Yeah, for sure.
Yeah,
and it's a 38-page document too, by the way. So it's not the easiest thing to go through, but we did it.
Alex Murdaugh. Is there anything new in that? I don't think so, but
Yeah, they're gonna retry him. It sounds like to me. It sounds like I don't know a whole lot about it, and it sounds like Stacey, you probably know more about it than I do. My understanding is there was a clerk, and the clerk passed some information that she shouldn't have, and so it sounds like they may retry him. And of course, if they do, I was mesmerized with that trial. Actually, Keith and I have a good friend in South Carolina. I won't say his name because without his permission, I won't do that. But he's a lawyer there in South Carolina. Actually knew Alex Murdaugh, knew him well. Told us a bunch of stories about him. I won't share those right now. But if that case does get retried, we'll fly down there and we'll get our friend. I almost said his name. We'll get our friend or her name. I'll get our friend and we'll do some podcasts down there on the Murdaugh trial.
Legalese flashcards. That's what they want.
Oh, that'd be cool. I can't imagine. I never would have guessed that.
12B6.
Yeah, 12B6. That's right.
Well, yeah, I guess that's pretty much it for today.
Listen, it's been a real pleasure to have everybody join us. We love your comments. Keith and I read them as we go home. Our families are always saying, why are you looking down at your phones? But we're reading your comments, and we do appreciate them very much.
Yeah, we appreciate all the support. We love the education, being able to bring our knowledge to you, and we'll keep on going. I'm sure we'll have more filings to come.
Yep. We'll see you guys next time. Take care for now.
Have a good evening.
You guys.